Thank you. Before the court is defendant's motion to exclude still photographers, TV cameras, and microphones from the courtroom. Defendant seeks an order categorically prohibiting any electronic media coverage during the pendency of this case. Because defendant has not shown that a categorical ban on electronic media coverage for all proceedings in this case is allowed by Utah law, defendant's motion is respectfully denied. At defendant's request, the court held an evidentiary hearing where Dr. Brian Edelman, a trial consultant, and Dr. Christine Ruva, a cognitive psychologist, testified in support of defendant's motion. Dr. Edelman conducted a survey of 200 people in Utah County and prepared a report with his assessment of the local community's consumption of media coverage of this case. His base findings reveal that 99% of the community members recognize the case and that 64% believe defendant is guilty based off what they have heard, read, or seen in the media. He examined press coverage of the hearings that have taken place since defendant's initial appearance in court and discovered that only about 25% of the viewers watched the live stream of the court hearings. A majority of the remaining viewers consume media commentary of the live stream recordings over social media and local television news sources. According to his research, the commentary from established news media does not provide a neutral summary of court proceedings. Rather, headlines and talking heads typically focus on out-of-court statements made by attorneys and prominent members of the community and country. As a result, viewers are led to believe that the comments made out of court, such as the comments about unadmitted evidence, are made during a court hearing and part of the criminal case. According to Dr. Edelman, this commentary primarily supports the prosecution's narrative and is used as entertainment, sensationalism, and commercialization rather than to educate the public on what is occurring during the court proceedings. Dr. Edelman also expressed concerns that media coverage of the security measures used during the court proceedings, combined with cameras in the courtroom, will be added pressure on the potential jury pool and contribute to potential jurors' reluctance to serve on a future jury. During cross-examination, Dr. Edelman testified that viewers who watch the live stream, usually on social media and streaming sites, are inundated with commentary from other viewers spreading misinformation. Although the commentary is being made by the public, it is not generated by the live stream itself. In his view, the commentary would not exist without the live stream of court proceedings. Dr. Edelman's opinion is that continued media coverage, electronic media coverage of court proceedings will perpetuate prejudicial and misleading views of the defendant and the evidence and affect defendant's fair trial rights. Dr. Ruva testified that she specializes in the study of jury decision-making, specifically how pretrial publicity affects memory and the deliberative process. Among other concepts, her studies focus on source primacy of pretrial publicity, which indicates that if jurors are front-loaded with the extensive amount of negative pretrial publicity toward a defendant, it is difficult to overcome their initial biases, even if presented with positive publicity about the defendant or negative publicity about an alleged victim. Dr. Ruva examined the pretrial publicity referenced in defendant's motion, which she summarized as provoking moral outrage and predominantly anti-defendant, full of dehumanizing language and accusations of guilt. Dr. Ruva explained that the jurors have a high amount of confidence that the information they use to reach a verdict is based on evidence that was presented at trial. However, research shows that jurors' memories cannot distinguish between what was heard at trial and what was heard from pretrial publicity. Jurors may even unconsciously distort evidence they hear during trial to align it with slanted information they heard pretrial. Because video and audio sources of pretrial publicity result in more emotional responses, these sources are better remembered than other sources of information. Dr. Ruva's expert opinion is that live streaming of all proceedings can lead to deep-seated bias in juror deliberations. And while juror questionnaires can help eliminate jurors with the explicit biases, they are not effective at identifying implicit biases. Dr. Ruva concluded with her expert opinion that to a reasonable degree of psychological certainty, this case is situated within a highly prejudicial pretrial environment that presents a substantial risk to juror impartiality. Based upon this evidence and an evaluation of the factors listed in Rule 4-401.01 of the Utah Rules of Judicial Administration, defendant argues that exclusion of electronic media is necessary to ensure Mr. Robinson's right to due process, to a fair and impartial jury, to counsel, and to be free from unreasonable searches and seizures, and to be free from cruel and unusual punishment as required by the 4th, 6th, 8th, and 14th Amendments to the United States Constitution and Article 1, Sections 7, 9, 10, 12, and 14 of the Utah Constitution. Members of the media, like members of the public, have constitutional rights to access criminal proceedings. Again, the citations will be in the order that will be filed. I will not read them right now. However, like the public, the news media does not have a constitutional right to photograph or video record public hearings and trials. Once beyond the confines of the courthouse, a news gathering agency may publicize within wide limits what its representatives have heard and seen in the courtroom, but the line is drawn at the courthouse door. Although electronic media coverage is not protected by the Constitution, neither does the Constitution ban electronic media simply because there is a danger that, in some cases, prejudicial broadcast accounts of pretrial and trial events may impair the ability of jurors to decide the issue of guilt or innocence uninfluenced by extraneous matter. Electronic media coverage provides a means to facilitate the public's right of access to court proceedings for those who cannot physically occupy the limited space available in a courtroom. Live streaming in particular allows as many people as are interested to observe the justice system at work and hold our branches of government accountable to the guarantees of due process. Defendant argues that the decision whether to allow electronic media coverage is governed by Shepard v. Maxwell, which held that there is a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial, that the court must take remedial measures to abate any threat to the fairness of the proceedings. Defendant argues that because video recording and streaming of court proceedings creates a reasonable likelihood of prejudicing defendant's right to a fair and impartial jury, this court should ban courtrooms for the remainder of the case. This court should ban media in the courtrooms for the remainder of the case. Consistent with Shepard, the court has taken remedial measures to abate threats to the fairness of these proceedings. For example, the court has positioned the video camera to the back of the courtroom, which has minimized, if not entirely mitigated, the potential for media to capture conversations at counsel's tables and documents on counsel's computer screens. The court has issued a robust decorum order to manage the proceedings and a pretrial publicity order to prevent statements from attorneys involved in the case from potentially prejudicing the jury pool. Rule 4-401.01 of the Utah Rules of Judicial Administration governs the court's determination of whether to grant or restrict electronic media coverage. The rule allows a news reporter to file a written request for permission to photograph or video record public proceedings. The rule creates a presumption that the permission will be granted as long as the predominant purpose of the electronic media coverage request is journalism or dissemination of news to the public. Defendant argues there is no presumption of electronic media coverage because the predominant purpose of dissemination of the court hearings in this case is not for journalism or the dissemination of news. Rather, it is for entertainment, sensationalism, and the promotion of commercial products. Defendant provided many examples of media outlets using footage of courtroom proceedings as background or as a springboard to discuss out-of-court commentary by public figures, opine on the relevance or existence of evidence that has not been admitted or presented in court, and generally vilify the defendant. The state referenced social media posts that have used media coverage of the case to promote conspiracy theories and to denigrate Charlie Kirk and his family. No evidence was presented by either party, showing a media outlet using live media coverage to educate the public about the progress of the legal proceedings or the justice system as a whole. This court is not so cynical as to conclude that just because the parties did not present evidence of responsible journalism, none exists. Defendant did not interrogate the use of the live stream of prior court proceedings by the news reporters who filed the electronic media coverage requests under Rule 4-401.01. Applying the plain language of the rule, it is the motives of these specific news reporters, the requesting reporters, that the court must question, not the entire universe of media outlets and social media sites that have published information or misinformation about this case. Because under Rule 4-401.01 sub 2A, the court must examine the motivations of specific news reporter who request to photograph or record the proceedings. Defendant's request for a blanket finding by this court that there is no presumption of electronic media coverage is respectfully denied. The court must determine whether the presumption applies on a request-by-request basis, depending on the predominant purpose of the requesting news reporter. Determining whether there is a presumption of media coverage is not the end of the analysis. The judge may prohibit or restrict electronic media coverage in those cases only if the judge finds that the reasons for doing so are sufficiently compelling to outweigh the presumption. The rule then lists 9 factors, some or all of which the court must consider to determine whether to limit electronic media coverage of court proceedings. Defendant argues that because the rules uses the phrase "in those cases," the court has authority to weigh the listed factors and find the presumption of electronic media coverage has been overcome for the pendency of a case, regardless of the type of the proceeding held. Reading the rule as a whole, the court disagrees with the defendant's interpretation. The court interprets the phrase "in those cases" to mean the same thing as "in those situations," where there is a presumption of electronic media coverage. The court's interpretation is consistent with subsections 2C and 2D of the rule. Subsection 2C requires the court to make particularized findings, denying or granting a particular request. And subsection 2D requires that those particularized findings to relate to the specific circumstances of the proceeding rather than reflect generalized views or preferences. Court proceedings vary in character and substance, ranging from scheduling conferences to oral arguments to evidentiary hearings and to the trial itself.